Attention. It worked. I didn't even have to whistle. Thank you very much, everybody, for coming this afternoon to, I don't know what it is, our 20th Stir Talk or something like that. We're getting up there. But thank you very much for coming, and it's with great pleasure that I introduce today's Stir Talk presenter, Professor Rick Duncan, who for many of you needs no introduction. Professor Duncan teaches property and constitutional law, and is not shy about his politics. He never has been. This year he's been a very popular guest on the circuit for the Federalist Society, traveling around the country, disseminating and distributing his gospel of his ideas. But I want to remind you all that Professor Duncan has a side that many of us don't see. He's an avid Bob Dylan fan with a remarkable collection of Dylan's recordings, including bootlegs. At heart, Professor Duncan is an outlaw. Today, his talk, as you can tell, is about the Hobby Lobby decision, and it's titled, Why the Hobby Lobby Decision Should Have Been Unanimous. And I assume that he'll also tell us why it wasn't. So please welcome Professor Rick Duncan.
Yeah, it's a pleasure to do this here. I've been doing this coast to coast, from everywhere from Brooklyn to BYU. BYU is not quite on the coast, but it's almost on the West Coast. But the problem here is we do this 15-minute version, and I've been doing a 30 to 35-minute version. So it's kind of like a movie director. All of my favorite scenes ended up on the cutting room floor. But we'll still try to walk you through this talk. So start the time now. Don't take it out of my time, the little introduction there. So time is very short for Stir Talk. So let's cut right to the chase and talk about the Hobby Lobby decision, a decision that I believe was correct and should have been unanimous. The case has generated much controversy. It's been criticized as waging a war against women, as banning access to contraceptives. And Justice Ginsburg even suggested that the male justices on the court might not be trustworthy because they have a blind spot when it comes to deciding women's issues. But you know what? Religious liberty is a women's issue. The first freedom is religious liberty, and religious liberty is for both men and women. And two women, Elizabeth Hahn and Barbara Green, were co-owners of the businesses that were fighting for religious liberty in the Hobby Lobby case, not to mention the Little Sisters of the Poor, a religious order of women who object to the contraceptive mandate and are also seeking the protection of religious liberty in a similar case against the contraceptive mandate. So this case is not about religious liberty versus women. Women are on both sides of this issue because women are not narrow, single-issue thinkers. They may care about contraceptives, but they also care about faith and about religious freedom. Nor is this case about women being denied access to contraceptives. No one was denied access to any contraceptive. All of Hobby Lobby's employees have total access to the entire range of FDA-approved contraceptives. And even after this decision, they will still get them for free. So on to the actual Supreme Court decision in this case. First thing to note, Hobby Lobby was not decided under the Free Exercise Clause of the First Amendment. It's not a constitutional case. Rather, the case was decided under something called the Religious Freedom Restoration Act, a civil rights law passed by a nearly unanimous bipartisan majority in both houses of Congress in 1993. Where's my clicker?
I thought you had it. Excellent question.
Time out.
It's in my pocket. Except now the laptop's asleep.
Justice Ginsburg, so you get a hold of Chris here. Didn't want this to come out. All right. Look at this. All right, so
Okay.
now everything's
Back where we were.
All right, good. We're okay now.
Time in.
Time in, yeah. As I said, this case was decided not under the First Amendment, but under the Religious Freedom Restoration Act, which is a civil rights law passed in Congress. And so let's look at RFRA. Let's look at the actual law that the court focused on. RFRA provides the following test to protect religious freedom. And the general rule is that government shall not substantially burden a person's exercise of religion. That's the general rule. Congress is telling itself, whatever you decide to do, whenever you pass a law, do it in a way that protects religious freedom. Congress is self-regulating itself. But there is an exception. And the exception is government may substantially burden religion. There we go. The exception is that government may substantially burden a person's exercise of religion if, but only if, it, that is government, demonstrates that the application of the burden on the person is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling governmental interest, a very high test. RFRA also defines the exercise of religion expansively as including any exercise of religion, whether or not compelled by or central to a system of religious belief. And then RFRA further provides that its protection of religious exercise, there it is there, slide 4, I guess. RFRA further provides that its protection of religious exercise must be construed in favor of a broad protection of religious exercise to the maximum extent permitted by the terms of this chapter, RFRA, and the Constitution. So RFRA is a federal civil rights law that protects religious exercise not just a little bit, but to the max. So let's break RFRA down into its component parts. There we go. And try to figure out how it works in a particular case. First, the law protects only a person's exercise of religion. So we're going to have an issue about whether a for-profit corporation is a person under the law. Second, the law is triggered whenever government substantially burdens a person's exercise of religion. And then finally, if a law, such as Obamacare, imposes a substantial burden on a person's exercise of religion, it will be struck down. It is invalid unless the government demonstrates that the law's application to that person asserting religious liberty is the least restrictive means of furthering a compelling governmental interest. Now, this is a balancing test weighted heavily against the government and against the law burdening religious exercise. This is what we call strict scrutiny in constitutional law. And it says to government, if you're going to burden religious liberty, you better have a really good reason. It's kind of like when my 16-year-old daughter comes home at 3 a.m., 3 hours past her curfew, and I've been up since midnight on the little cell phone. This is exactly, I do one finger. Where are you? When are you coming home? Are you okay? Do you need me to come get you, right? And then she walks in the door 3 hours late. And what do I say to her? You better have a really good reason for being out this late, or you're going to be grounded for the rest of your life. Not a regular reason, not even a good reason, but a really good reason. So she says, well, Dad, the movie ran a little long. I go, well, that's a reason, but it's not a really good reason. She says, well, Dad, my best friend broke up with her boyfriend, and she needed to talk to somebody. Well, that's a good reason, but it's not a really good reason. She says, well, on the way home, there was a school bus accident, and I get out of my car and I did CPR and I saved 5 young children's lives. I go, that's a really good reason. Here's your get out of jail free card. Anytime you want to save 5 lives, you can come home 3 hours late. And under RFRA, it's not sufficient to show that the law is designed to serve a legitimate state interest, nor even an important state interest, only a compellingly important state interest. A state interest of the highest order and of the greatest importance will suffice to permit government to substantially burden religious liberty. And even if the interest is compellingly important, even if the government gets through that first hoop, government must also demonstrate that it has used the least restrictive means of furthering that compellingly important state interest. If there is any other way to advance that compelling interest without restricting religious liberty, government will lose under RFRA. So Obamacare passes, HHS writes a rule requiring employers to cover all FDA-approved contraceptive methods and sterilization procedures. And Hobby Lobby and some other closely held corporate businesses object because their sincerely held religious beliefs forbid them from providing any type of contraceptive that operates after the moment of conception. So basically, Hobby Lobby has religious objections to providing coverage for the morning after pill, the Plan B pill, the week after pill, Ella, and IUDs, because Hobby Lobby believes, and the FDA actually has supported this belief, that these methods of contraception are in effect abortifacients because they operate after conception. So the issue before the court was to apply RFRA to Hobby Lobby's claim against the contraceptive mandate. The court upheld Hobby Lobby's religious liberty claim under RFRA in a 5-4 decision. I think it should have been unanimous, and as we walk through the law, you'll see why. And let's take a walk through Justice Alito's opinion in the case. But before we go through the court's analysis in the case, I want to pose a hypothetical that involves only a slight change of the facts in the case. Suppose that HHS also mandated that employers cover not just contraceptives, but also all surgical abortions, including abortions performed at 6 weeks, 12 weeks, 20 weeks, and even 30 weeks of pregnancy. Suppose there was a surgical abortion mandate that HHS imposed on all employers. If Hobby Lobby is not protected against the contraceptive mandate, would it also be unprotected against a surgical abortion mandate? I think the answer is yes. It either wins both of these cases or it loses both of these cases. So, first issue is a closely held for-profit business, a closely held for-profit corporation, a person under RFRA. Well, RFRA is a federal civil rights law. And Congress has passed something called the Dictionary Act. And the Dictionary Act provides that in determining the meaning of any act of Congress, including RFRA, unless the context otherwise requires, the word person includes corporations, companies, associations, firms, partnerships, societies, and joint stock companies, as well as individuals. So Congress itself has said when we use the word person in any of our statutes, the word person includes corporations. Justice Alito concluded that the Dictionary Act governs the issue of RFRA's coverage because there was absolutely nothing that suggests that when Congress enacted RFRA, it intended to depart from the Dictionary Act definition of person as including corporation. And remember, even if there were two possible constructions, the broad construction provision orders the courts to adopt the broad construction, the construction that would maximize the protection of religious freedom. So even if there were two possible constructions, Congress itself says go with the broad construction to maximize the protection of religious liberty. Now, I think one of the reasons that Citizens United gets some people so upset is what I call Citizens United road rage. The very fact that the courts might recognize that a corporation has rights makes some people growl and grrr and get very upset. You know, how dare the court say that corporations have rights? Corporations are mean, corporations are ugly, corporations don't deserve to have any rights. But again, the decision to include corporations as persons in this case was made by Congress, not by the Supreme Court. The Supreme Court's not imposing this definition of person on Congress. Congress said in the Dictionary Act, whenever it uses the term person in any act of Congress, the term person includes corporations, companies, and similar business entities. But even if a corporation is a legal person under RFRA, how does a corporation exercise religion? Asked Justice Sotomayor at oral argument in the case. Surely a corporation has no heart, no soul, no spirit, and thus is unable to exercise religion. Hobby Lobby is a for-profit corporation, and a for-profit corporation exists solely for the purpose of making a profit. Well, there seems to be a consensus among supporters of Obamacare, let's say, that corporations are incapable of having a religious conscience and thus cannot engage in religious exercise. But many of these same people often demand that corporations have a social conscience and that corporations should act on their social consciences by adopting green policies to protect the environment, by following fair trade standards when dealing with third world producers of products, and by donating money to support various causes such as Planned Parenthood or the Sierra Club or whoever. So apparently a for-profit corporation is capable of having a social conscience, but it is not capable of having a religious conscience. That doesn't seem logical. And the court held that corporate persons are indeed capable of exercising religion just as they can exercise corporate morality. And that modern corporation law, the court looked to the corporation law of the states, and the court said modern corporation law does not require for-profit corporations to pursue profit at the expense of everything else. State corporation law makes clear that corporations may be formed for any lawful purpose or purposes. And that includes running a business as a Christian business, as a religious business, or as a socially conscious business. So therefore, Hobby Lobby may act in accordance with the humanitarian or altruistic or religious consciences of their owners, and thus are indeed capable of exercising religion under RFRA. So says Justice Alito and the majority. And in this case, this is the perfect client. David and Barbara Green and their children are the sole owners of Hobby Lobby. The Green family are devout Christians, and each member of the family actually has signed a pledge to run the business in accordance with the family's religious beliefs. Moreover, Hobby Lobby's statement of corporate purpose commits the Greens to, quote, honoring the Lord in all they do by operating the company in a manner consistent with biblical principles. And long before Obamacare ever came along, the Greens operated the business that way. They close on Sundays, even though that's one of the most profitable days for businesses like Hobby Lobby. They don't want to interfere with their employees' ability to worship on Sundays. They pay, and have always paid, well more than the minimum wage. And long before Obamacare required employers to cover health insurance, the Hobby Lobby provided health insurance for its employees because, again, the company feels it has an obligation to take care of its employees. So there can be no doubt that Hobby Lobby was created for the purpose of operating as a Christian business, nor can there be any doubt that the contraceptive mandate prevented Hobby Lobby from operating in a manner consistent with its statement of purpose. So I think Alito clearly got the RFRA exercise of religion issue right. The next issue is, does the contraceptive mandate impose a substantial burden on Hobby Lobby's exercise of religion? Well, under Obamacare, if an employer offers a group health insurance plan that does not cover all of the contraceptives required by the contraceptive mandate, the company must pay a penalty of $100 per day for each employee covered by the plan. In Hobby Lobby's case, the penalty would be $475 million per year. $500 million per year.
Sorry, that's 15 minutes.
Oh, well, I'm going to go a little bit more. I'm sorry. We had so many, I'm sure you didn't give me credit for all the interruptions. Because I can't leave you hanging here. And so the court said that's a substantial burden. $475 billion. HHS basically told Hobby Lobby, either perform an action that deeply offends your sincerely held religious beliefs, or pay a $475 million per year penalty. And so once that happens, a substantial burden on free exercise. Now we apply strict scrutiny, and the issue is does the state have a compelling interest? Does Congress have a compelling interest in imposing the contraceptive mandate on all employers? And even if the answer is yes, is there a less restrictive means of accomplishing that compelling interest? Well, to make a long story short, the court assumed without deciding that Congress did in fact have a compelling interest in the contraceptive mandate. I think it's very arguable whether this is one of the most important things that the federal government could possibly do. But the court said, we'll assume without deciding that there's a compelling interest, because in any event, the least restrictive means standard is exceptionally demanding. It's a gauntlet of superlatives that the government has to pass through when it restricts religious liberty. Because there's more than one way to skin a cat, and there's more than one way for HHS to ensure that Hobby Lobby's employees receive free contraceptives. Think about this. HHS wants Hobby Lobby's employees to get free contraceptives. One way to do this is to require Hobby Lobby to provide coverage, notwithstanding its religious objections. But that is the most restrictive way, not the least restrictive means. Are there other ways for government to make sure that Hobby Lobby's employees get free contraceptives? Well, if it's so darn compelling, the court suggested the federal government itself could purchase contraceptive coverage for women whose employers opt out of coverage under RFRA. That would be less restrictive of religious freedom. And the cost is chump change in light of the $3.5 trillion federal budget. The cost would be minimal for the federal government to do this. But there's even an easier way to do this. HHS itself has discovered that insurance companies can directly provide free contraceptive coverage to employees whose employers opt out under RFRA, and that this option is cost-free to the insurance companies because the extra expense of providing contraceptive coverage is offset by the savings resulting from fewer unplanned pregnancies, and thus less coverage of maternity services and childbirth. So there are less restrictive means. The HHS can require the insurance companies to directly do it, can allow Hobby Lobby to opt out. And therefore, Hobby Lobby wins the case because Congress was not able to show that the contraceptive mandate was the least restrictive means of imposing, of advancing a compellingly important interest. So Hobby Lobby wins, but its employees will still have access to free contraceptives. So it looks like a win-win. Why all the shouting and protests and end-of-the-world prophecies coming from the New York Times and HuffPo and MSNBC? And I think the answer is that religious freedom scares some people, particularly supporters of big government, because the idea that someone can opt out of a wonderful law like Obamacare based upon a claim of higher authority frightens them. Superstition should never trump social progress, I think is the way the thinking goes. But Hobby Lobby is important because it stands for the proposition that religious freedom is an important civil right, and that religious people do not give up their right to religious liberty when they decide to go into business, even if they decide to incorporate their business. That is the short, slightly more than 15-minute version of the talk, but I'll hang around. I'll be happy to answer questions for anyone who wants to come up. Thank you.